All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We're here for oral argument in case number 1 cv17-0024, Camille Morgan Amador, petitioner appellant, versus Stephen Paul Lifgren, respondent appellee. Counsel, remind you that these proceedings, or this proceeding, is being recorded. So if you'll please identify yourselves and who you represent at the beginning of your arguments, that would be appreciated. Each of you will have 20 minutes in which to present your arguments. Appellant's counsel, if you'll watch the clock and reserve as much time as you would like for rebuttal. And also, please keep in mind we've read the briefs and conferenced the case this morning prior to argument. With that, Mr. Berkshire, you may proceed.
Morning. May it please the court, my name is Keith Berkshire, attorney for the appellant, Cami Amador. I wanted to start with, I think, one of the more direct issues here, which is the application of 25-527 to the overage payment. Our position is that this statute is the exclusive remedy to receive an overage payment. The only case that has dealt with this is, as the court's aware in the briefs, the Allen case, which is a long-term disability application case to a child support modification. Allen is based on the Clay and my case Kiefer, regarding an overpayment through, recaptured overpayment through essentially a child support deviation. Here, the court found there is no deviation. So it basically precludes the application of Allen. If you could get around the statute this easy, the statute has no meaning. I mean, the statute, including the statute of limitations, says how you get an overage payment. This is done daily in family court. Every modification usually results in an arrearage or an overage anytime child support is modified.
So what, as a practical matter, what happens? Those go to some, those are stored in the repository of reimbursements, and
yes,
I'm being facetious, but they're stored somewhere, they're kept on file, and a parent, when the youngest child turns 18, or there's otherwise a termination, and then that parent who is entitled to the reimbursement or overpayment can seek to turn it into a judgment?
Exactly. That is exactly what happens.
You're saying that's it. That's
these
it.
Sit out there.
That's the sole remedy.
These sit out there for years, if not decades, as overpayment. And the purpose behind the statute is obviously pretty clear, which is to ensure there's payment. I mean, the court can bond child support payments if it wants to, but that is the remedy. The statute gives the remedy, which is when the child emancipates. It doesn't say when or by other order of the court. It says upon emancipation or termination of child support. It doesn't add the language, or if the court wants to do it earlier than that. It says this is when you get the overage payment. It's implicit in every modification. If a modification occurs, is some sort of deficiency or overage one way or the other.
But here we don't have. Here there is no judgment. So what's
well, child support is a judgment as a matter of law each time the payment comes due. So there's a judgment on every single payment and every single child support order.
The $500 a month is a judgment. The $1,430 is a judgment.
Correct.
Okay, assuming that's true, why couldn't the court? Well, if we were to remand this, why couldn't the court, if it was inclined to do so, issue specific findings of it, just saying, listen, for these children, for this time period, I do find there's a downward deviation is necessary and appropriate, best interest of the children for this time period in order to
it would have to do
even
that.
Things out.
Well, that's the issue.
Could the court do that?
I still don't believe so. Because again, Allen is one of these unique cases where somebody gets this massive Social Security or long-term disability payment. Because they apply for it, it takes, like in my case, Kiefer, it took, years to get the Social Security disability payment, and then they get this windfall and so forth, and in the meantime, somebody was overpaid. It wasn't just a normal modification. Allen's the outlier in these types of cases. But even if that was the case, Your Honor, the court specifically already found there was no deviation. So the fact that the court found no deviation, and no deviation was in the best interest, precludes that remedy in this case anyway, because there's a specific finding that it wouldn't be in the best interest of the children to deviate. But in doing so, if the court was going to do that, they'd have to go through all the 320F factors on a deviation to show why the children need less money in the meantime. So even if they could, I think the court's findings already preclude it in this case.
And does the record show, is there anything in the record showing that the children needed less money in the meantime?
No, actually, all the testimony was about that the deviation, because this was an upward deviation case initially. The decree was an upward deviation. So there was no testimony. Father's position was apply the child support guidelines. That's the irony here. His father said apply the calculator. He didn't argue deviation. He argued repay me, but apply the calculator. So his own position taken, meaning the child support guideline calculator, he didn't argue for a downward deviation. He said apply the child support guidelines. So his positions take it.
So, counsel, you rely on 25-527 with regards to the overpayment and the manner in which the lower court ordered that be repaid to father, but doesn't that statute address instances where the support obligation has already terminated? I mean, it's not necessarily addressing a situation such as this.
I think this is a statutory remedy for overpayment, the same as arrearages are a remedy.
But it specifically says when the obligation is terminated.
I think it creates that implicit this is the sole remedy to get overages.
Whether the support obligation has terminated or not?
I believe so. I mean, there's no exception to saying if the child support, I mean, the legislature could have had a language about if the child support order hasn't terminated, the court can still make an overage payment. It says here is how you get an overage payment if the kid is emancipated and everything has been paid. So the next issue, I think, maybe simpler, is the percentages for child support, the uncovered medical expenses. Arizona follows an income shares model in our guidelines. It's implicit throughout the entirety of the guidelines that the child support is paid specifically in percentage of income. Daycare is paid in percentage of income. Medical expenses added into the child support worksheet are paid in percentage of income. By not following the child support worksheet percentages on this limited exception creates this dichotomy of medical insurance versus uncovered medical expenses. So if someone was paying, let's say the worksheet worked out that it was 90-10, 90% to one party and 10% to the other, they would actually get a benefit to pay for cheaper medical insurance and create, but yet then the uncoverages were 50-50. They would actually be benefited by paying for cheaper medical insurance that had a higher out-of-pocket because they would be paying less money overall. That is why we follow income shares. Everything that goes into the worksheet. If I add daycare into the worksheet, it is paid in percentage of income. If I add medical insurance into the income or tuition for private school, it is implicitly paid in percentage.
It seems to me that your logic is sound, but it's not expressed in the guidelines as such.
In this one section, it is the only section that doesn't discuss that in percentage to income.
So aren't we left with authority for a 50-50?
In other words, when the court doesn't speak, I mean, the Supreme Court doesn't say, are they silent, don't we assume that means...
Well, but I think you look at the purposes of the guidelines and the rest. You can't read one section. I mean, you've got all the statutory interpretation methods that talk about you can't read one section and exclude the others. Every other section discusses this, and it's implicit in just simply how child support is calculated in the first place. I mean, this is, for all intents and purposes, a deviation as well, because it's not following the percentages created by the worksheet in and of itself. I mean, this is, let's say that the child care was just left out. One party wanted to put it in and one party left it out. It creates two different methods. The worksheet just in and of itself creates the percentages. Anything in the worksheet is automatically divided in the percentages. So again, here, if insurance covered, let's say we had a $2,000 a month medical insurance policy that was zero deductibles, that would be automatically by percentage. If we had a free policy that was massive deductibles, then under this court's ruling, it would be by the 50-50. There's no reasoning behind why there was a change here. There's no analysis by the court saying why they didn't follow the standard procedure and the percentages that are dictated in the Excel sheet created by the court that does this. These things autofill into these are the percentages.
So the Supreme Court created the worksheet as well as the guidelines.
The Supreme Court doesn't do. There's actually a child support guideline committee that's not. There's two, and then it gets into this, and one got rid of, but they do. This is it is a court provided worksheet. And it fills in these percentages automatically in Excel when you do these things. It's a court created document that you get literally off the court's website.
What court created it?
I'm not sure who actually created it, but it's on all of the Superior Court and the Arizona Supreme Court's website. The Excel sheet in and of itself is on that website. I want to get to the kind of more major issue, I guess, which is the actual modification. This case is very interesting on how the court looked at the modification. When Father first filed his first modification, the child support in 2014, Father alleged in his petition something very simple, which is parenting time is going to change. We should change child support to match the new parenting time order and current financial circumstances of parties. When he filed a year later for spousal maintenance, he specifically alleged mother's a realtor and is working. What is undisputed here is mother never actually made any money from being a realtor. She never made any money between that 2014 and the 2015 modifications.
She didn't make any significant money.
Well, nothing that came close to what the court attributed.
Doesn't the record show around $350
It was
per month?
It's something very small.
So she made, the point here is whether Father misstated.
Well, I think that well below the self-support reserve test, well below anything that would have applied any actual income to her, definitely what she could have made at the divorce time as well.
Mm-hmm. Well below, but he didn't lie when he said she was making money, some money, hardly any.
We're happy to use $300 a month as income.
So the question was whether there's a substantial change in circumstances.
Correct. So, but the interesting part here is how the court, Father wants hindsight on mother's job that she obtained after the 2015 modification. He wants the court to use that income, a job that no one predicted from that standpoint. It wasn't a change at the time. He wants hindsight to be perfect and apply her income at that time for the spousal. He doesn't want hindsight for the child support modification during that year that there is no income or no substantial income of any kind. Definitely not the $42,000 that the court used during that year. During that first year, 2014 to 15, she made nothing more than she could have at the time of the decree. There was no possible modification. What the court did was attribute her a real estate job. I don't think it's really a far stretch to say there's a lot of realtors out there that have a real estate license because it's a 2-week course. These people aren't automatically making $40,000 a year. There was no evidence she should have been making. There was no allegation that she was being lazy and not pursuing work and just sitting around, but she could have made that money. They attributed her a job. The court attributed her a job she ended up never having from the standpoint. Then the court used her other job, which she was qualified to get at the time of the divorce. The real estate in this is just this misnomer because she never actually worked or made any money of that. Definitely not between 2014 and 15.
When did she start making the $42,000?
So the $42,000 was the month after Father filed his spousal maintenance modification. Now, our problem with how this court looks at it, this case took a long time. So hindsight's great here, but that's not and should not be the standard for when you file to modify support. You shouldn't be able to preemptively file support modifications hoping that something happens, because family court's got enough litigation already that if people can say, oh, I think they're going to do this, I'm going to file the case, let it drag out for 2.5 years, and hope in the meantime they make more money. The standard is at the time. We could look at the Scott case, which is a broadcaster TV broadcaster who alleged that he was making less money as a broadcaster. Even though he had provable tax returns, etc., showing that for 1.5 to 2 years he made less money, the court found there wasn't a change because it wasn't a long enough continuing change of circumstance here. At the time father filed this, there was no change. She didn't have a job. She was making $300 a month. Now, he lucked out, and she went and got a job. Not the job he alleged that was the continuing change. She got a different job she was qualified to do at the time they entered the decree. Didn't require any more training, anything else. What they're...
So your position is that it should begin from the time she started to make the $42,000.
I think that the petition should have been denied because I think the standard should be when you file the petition, the change has to exist at the time you file the petition.
There should have been a new, in your opinion, there should have been a new petition filed when she obtained the new job, or at least an amendment to the petition.
I think that there should have been a new petition filed sufficient time after she obtained the new job to show that it's a continuing change of circumstance. We have case law all over the place that is these short-term or temporary changes in income do not qualify for a change of circumstance. How was your first month on a job that you've never had before, for the first time in your life, a long-term continuing change of circumstance? Again, in the Scott case, the guy's income dropped for over a year to 2 years, and the court said it wasn't changed because it wasn't continuing. That's the issue here. He lucked out. He filed it right prior. If this was, I mean, on the spousal, on the child support, he filed 13 months prior to her making any income. And the court used that date 13 months earlier. That clearly wasn't a continuing change for the child support purposes. But even here, this shouldn't be file and luck out that they end up getting the job. This isn't somebody who, is graduating from a fellowship at the Mayo Clinic that you're pretty sure that they have a 99% chance of getting a job. This isn't that standard. Let's use lawyers, for example. Saying every law grad that passes the bar automatically has employment. That's what the court did, is he lucked out. She got a job, and they used that different job than he alleged as her income. The standard has to be, from a public policy standpoint, when you file, that is the point the court looks at to determine if there's a change, because otherwise all of these changes are going to be filed just as preemptory actions before, just again, hoping that something happens, hoping I do enough discovery and hoping the case takes 2 years, and then, hey, I lucked out. I don't have to wait for the change. I can just file it and drag the case out. We've already got that enough in family court. We don't need more preemptory actions in that regard. But I think there is a big distinction, especially between the child support case and the spousal. The child support, again, you've got 13 months that she wasn't earning anything. That one is, the spousal, at least there's an argument, hey, it was the month prior and she did work. But the child support, there isn't. It was 13 months. And at that point, they had a deviation of over $1,500 a month. How can we say that there was a change in circumstance enough to deviate, especially when she wasn't making any money? This is an attribution to a job she'd never had, to a circumstance that has never existed. All the case law we have about attribution of income is there has to be some reasonable prospect that you're going to earn the money. There's no evidence this is the average salary for realtors. There's no evidence that, an expert in place saying she's just sitting around and could have easily been making this money. That wasn't the case here. It was simply the court just utilized her next job, not in real estate, totally different industry, as if that was the same income somehow. 2 different industries for that attribution. So with that, I'm going to save my last 2.5 minutes.
Thank you. Counsel?
Good morning. Steve Everts on behalf of the respondent in the lower court, the appellee in this court, Stephen Lifgren. I'm going to begin by attacking the very significant argument in this case, which has to do with the modification of spousal maintenance. I want to put this argument in really frank perspective for this court. What the mother is asking happen in this case is that she went out and got a default decree which had an indefinite award of spousal maintenance. It was contemplated by both parties that she was not working at the time and didn't have to work, or at least they thought that she didn't have to work. But if she did, she could work for as long as she wanted, make as much money as she could, and there'd be no impact whatsoever on her spousal maintenance award. The sheer mention of that particular statement demonstrates the illogic position taken by the mother in connection with this case. The substantial and continuing change of circumstances with regard to spousal maintenance occurred within 3 weeks after the father filed his petition. And just to make sure, I use these benchmarks for me, so I'll give them to you. 2013 was the decree. 14 was the first petition for the modification of child support. By the way, both parties asked the child support to be modified, not just father. 2015 was father's second petition to modify spousal maintenance. And 2016, June, was the hearing in this particular case. The ruling came out a few months later. At the time that father filed, and I'll start with the modification of spousal maintenance, the petition for modification of spousal maintenance, mother had already worked as a real estate agent all the way from May of 2014 when she got her license. Now remember, she didn't just get her license. She got her license, she hung her license with a broker, she worked, and she made some income. So when he...
How much did she make?
Not a lot.
About?
I don't think there's any dispute with the figures that the court earlier said about $300. Yes.
But you would agree that did not constitute a continuing change of continuing and substantial change of circumstances.
Well, looking backwards, it may not have, but at the time father filed his petition, he had a good faith understanding that she was working, hung her license, and was making income, so he had a right to file the petition. He also asked for a modification of parenting time, which would have adjusted the child support. So both of those factors would have been reasons
Adjusted
why.
child support, but it wouldn't have adjusted spousal maintenance.
No, I'm now referring to the first petition, but the spousal maintenance petition occurred later in 2015. And when he filed that petition, she'd already been working in the real estate field, at least allegedly, for a long period of time, over a year and a half. And then, within 3 weeks after he filed the petition, the change occurred where mother obtained a job and made $42,500 per year. Now, let's address this, what I call rather silly argument, that you have to know all the facts at the time you file a petition. Most people file a petition because they assume and are making a good faith basis that there's a reason for modifying something. So in this case, you modify spousal maintenance because you assume she's working and making money. And there's other reasons that he had which are collateral to what this appeal involves. If a person gets a job 3 weeks afterwards, mother's position is you cannot bring up that fact at a hearing in June of the next year, 9 months or so later. Do you know what that would do to the court system if we had to have a system that worked in that fashion? He talks about the fact that that it would create a bad precedent to allow that to occur. The bad precedent would be this. You go to a trial in June of 2016 and you're not allowed to talk about the truth or the facts that existed on that particular date.
Change the facts a little bit. What if she got the job 3 weeks prior to the hearing date?
The court would then have...
It would be the same, you would have the same answer. It'd be evidence of substantial changes, sir?
Well, I'm not going to try to predetermine what the judge would do, but I will tell you this. He has the right to make the decision as to whether he has the right, and it's a finding that he has the right to make, as whether there's not a substantial and continuing change of circumstances. Certainly from November of 2015 through June of 2016, she had worked long enough at a 42.5 job that would have constituted a long enough period of time for the court to make the finding. I don't know what would have happened 3 weeks prior to the date that the hearing was held. The court would have had to still make a similar decision, and they would have had to weigh the factors at that particular point in time.
Point is, every case, every job is going to be evaluated differently.
Correct. Everyone is going to have its own unique facts, and we give great deference to the trial court in making these decisions because they're the ones that hear the evidence and consider it, and we don't overturn them unless there's a good reason, and it's not in this case. So the chaos would occur if you can't hear the facts after the hearing or up to the date of the hearing. If you had to say, okay, the petition was filed in October of 2015. She gets a job in November of 2015. We have a hearing in June of 2016, and you can't bring up those facts at the time that you have the hearing. Then what do? Say, okay, Judge, we're going to try this case on the information that existed a year ago. And then after we get through with this hearing, by the way, Dad may come back and file another petition to allege the same facts that you just could have heard at this hearing. So how many more hearings will you go? And every 2 years we come back and argue about facts that are old and not litigate the ones that are new? That would be an idiotic way in which to run the court system. The court is entitled to hear the truth and the facts as they exist on the date of the hearing, and that's exactly what Judge Whitehead did in this particular case. So we start with the principle that he accurately modified the spousal maintenance, and he terminated it. By the way, it replaced the amount of money that mother had already been getting for spousal maintenance. She was getting $24,000 a year. She was earning $42,500 per year, almost twice as much as she was getting. Her position, one of the indicators that shows how ridiculous the argument is that she would like you to believe that she could go out and make $42,500 and still keep getting $60,000 per year $3,000 for child support and $2,000 for spousal maintenance, which would mean she would end up with $102,500 per year in the total payments that she was receiving. That's the position she's taking in this case. It would not be adversely impacted. So the court clearly had a right to take into consideration her job and modify the spousal maintenance.
Did the court clearly have a right to impute income for the 13-month period for her real estate?
Are we
just
talking
the sake of having a real estate license?
We're talking.
That seems problematic to me.
We're talking now about the modification of
Yes,
child support.
yes.
Yes.
This is it October 2014 to November 2015? I think that's what we're talking about, isn't it?
Yes. The order on the modification of child support. Yes, sir.
Just wanted to keep the
Yes.
keep the
No, that's
details in
okay.
mind.
There's two kinds of income. There's actual income and there's imputed income. And imputed income includes what one would make with their earning capacity. There's no other conclusion in this case, but Judge Whitehead took into consideration wife's earning capacity in order to make child support retroactive back to the date of the filing of the petition. That's what he had to do in order to reach the conclusion that he did. So what are the facts that he used to do that? And is this court going to give him deference to those facts or not going to give him deference to those facts? The facts were, when she took the job for $42,500, there was no evidence introduced. Now, father said she could earn the income backwards, and she should have been able to earn that a year earlier. Mother did not oppose the information and say that she couldn't get the job or demonstrate any facts to suggest that that job wasn't available. She couldn't get it. There was an employee that had to leave, anything like that.
Didn't she say she was working and working really hard and all she could make was $300?
She was working in the real estate
license?
field. Yes.
Right. So isn't that contradictory? She says, I have this license and I'm working as hard as I can. I've got the kids making flyers. I'm doing all of this and I'm just not able to make more than, not even minimum.
I'm not disputing what she said because it's in the record, but I think the trial court has the right to determine whether or not that's reliable information or whether or not it's reasonable and whether or not that justifies the earning capacity that he imputed to her of the $42,500 a year earlier.
So your position is that the court imputed income based on the fact that she had a license? A real estate license?
No, I think he imputed the income based on the fact that she obtained a job for $42,500 and there was no evidence produced by her that that job wasn't available and she couldn't earn it a year earlier.
And where is that on the record?
That he made that finding? Well, that it has to be done. How else does he get to October of 2014?
That's our question.
It's an implicit finding.
It's an implicit finding in the order that he entered. He had to make that finding or else he couldn't have got there.
Could the well, so if his implicit finding depends on the 42.5, what if the child support modification was filed even earlier than it was? Could he go back that far? How far back could he go?
Oh, I'd like to speculate about what he could have done in that 15 or 18 months after the date of the decree, but I don't know that I could be that clairvoyant, Your Honor. I would say this, that she had a year and a half to work. There wasn't any evidence demonstrated that she couldn't have gotten that job earlier, and therefore he had the right to determine that was her earning capacity. And that's what he had to do in order to reach the child support figures that he did. That's the only way that he can do it. With regard to each of these issues on the substantial and continuing change of circumstances, there's the retroactivity issue both for child support and for spousal maintenance and for child support. With regard to the child support issue, there's also the issue about the deviation upward. I hope that that's now been settled by the case law that we've cited in the brief. The deviation does not carry forward after it's been once granted. You have a new child support figure and you can start from scratch. You don't have to go back and grant the deviation going forward. That should solve the issues with regard to those, with those two particular issues and why Father's order should be affirmed. I want to address a few of these things in the minutes that I have left that have been raised by counsel with regard to the other collateral issues that are in the appeal, unless you have any other questions on those. Which I'll move to.
I'd like you to address the, I think it's 25527 argument.
That's exactly where I'm going. Thank you, Your Honor.
Thank you.
The overpayment issue on 527, obviously it's our position that it is not the exclusive remedy, and the reason is because Father was not seeking a judgment in this case. From the time he filed his original petition and the 4 worksheets that he produced, he was asking the court to credit the child support obligation with the overages that had been paid as a result of the retroactivity of both child support and spousal maintenance.
Doesn't the statute suggest that that can only be done after all of the obligations have first been paid.
I don't believe so. I believe that the other option, that's assuming that the child support obligation is now terminated. And if you read the statute carefully, it also uses the word may, and it also says you have 2 years after that. It's like a statute of limitations is raised. So you assume that the children have emancipated and we're now trying to recover a judgment. In this particular case, the child support obligation, as the court has already acknowledged, was still in progress. We weren't asking for a judgment. Father wasn't asking for a judgment. And the Allen case recognizes that there are other ways in which a person may be compensated. Noted in the footnotes of the Allen case were the fact that there were a number of years, in this case there were 10 more years, in which father's money would have to sit in the clearinghouse until he actually received it back, or get it from mother in some other fashion.
What about Mr. Berkshire's point that the family court, especially Maricopa County, is full of these types of, many parents are sitting waiting for their money. I mean, does the court have authority in every one of those instances to deviate from the child support guidelines and start, and reimburse those parents?
The court has the authority. Whether they choose to do it or not will depend on the facts of each case. They have to make the findings for the deviation to occur, as the Allen case pointed out. And that's my one comment about this particular case.
Are you aware of any MEM decision, reported authority, even a MEM decision where that's actually occurred, where a court has done a downward, accomplished or ordered a downward deviation for the purpose of reimbursing a parent's overpayment?
I don't have a site that I can provide to the court. I know from practical experience it happens on occasion in trial courts. Whether or not it's been an appeal, I don't know yet. On
this record, just why, what evidence is there that it was in the child's best interest to modify from 1430 to 500? What evidence supports that finding? Because of course we're supposed to review to make sure that there's reasonable evidence in the record supporting the court's findings.
I can only infer it from the record because Judge Whitehead did not make the findings. In fact, I said that if the court chose to do so, they'd have to remand it in order for him to make them. I want to make sure it's clear too. Let me answer your question first of all. The inference that would have to be drawn is that that the mother had already received the payments and therefore had a surplus of cash that could be used to pay for the obligations of the children. And that would be the finding of that it was in the best interest of the child. Now, he may do that if you remand it to him in order to provide that for him or not. But I want to address this idea, too, that he specifically and expressly stated counsel was correct in the minute entry that there was no deviation. He said that in the minute entry. But that was with regard to a different subject. If you remember, he made the determination the real child support in this case was over $1,400. And he credited the $900 difference between the $1,400 and change back to $500. And that was the credit that mother was receiving. The no deviation that he referenced the $1,400 child support obligation. In other words, he used the exact factors on the worksheet, didn't deviate. It was $1,400. The credit is the part that doesn't have the deviation language. But he definitely used it or had to have done to have reached that figure.
To have reached the 1,400.
He didn't deviate to get to 1,400. He deviated to get to 500. He chose not to enforce the deviation from the prior order in this particular case. Unreimbursed medical expenses I want to just touch on for a second. The total child support figure that is referenced is not including unreimbursed medical expenses. It is not including dependency exemptions or their allocation. They're treated separately off the worksheet. So when we say you can add the over 12 adjustment, you can add the extra education expense, you can add the medical insurance, which you do to arrive at a total child support obligation, and that's divided proportionate to incomes, that's great. But that's not what we're talking about here because these items are off the worksheet. The court completely has discretion, and we've cited the specific rule, and I think it's under Section 9 of the guidelines, which allows the court to pick the amount of the pro rata or the equal division of the unreimbursed medical expenses or the dependency exemptions.
You're saying these would fall in the same category, for instance, the kids' extracurricular activities?
Correct.
Could be divided however the court
Absolutely.
deems that appropriate.
Lots of parties even agree, and then they still let the court decide how to divide extracurricular expenses or other things off the worksheet. Sometimes private daycare. Sometimes they pay it off the worksheet. It isn't on the worksheet. So how they divide it and the proportions that they use are within the discretion of the trial court, and this court needs to affirm our trial court for having made that decision. If we didn't do this, there would be hundreds of orders out there floating around in this county as well as others that I'm sure would have to be modified, because there are many of them that have a 50-50 proration of the unreimbursed medical expenses, regardless of what the incomes of the parties are. I wanted to also mention another thought that I had with regard, and I don't know where the court will end up going with this, but with regard to the spousal maintenance obligation and this idea that it's an indefinite award, I want to make sure that our position is clear. When an order uses indefinite spousal maintenance, I want it understood, it does not mean forever. That's not the definition of the word indefinite. Indefinite is the opposite of definite. It means not definite. And when we have something not definite, it means it's flexible. In this case, spousal maintenance is either modifiable or it's not. It's modifiable. This was a default decree, not a consent decree, not an order by the court. For that matter, the court couldn't enter a non-modifiable order under 319C. They have to enter an order that's modifiable. So the only question here is, did the substantial and continuing change of circumstances occur? Mother could have not worked if she had chosen to do so in the beginning. She wasn't working, and the parties all understood that when they entered the order. But nobody can prove, and Mother certainly didn't, that there was an understanding that if she did go to work and make $42,500 a year, that meant we were going to continue the spousal maintenance forward without modifying it. There's no inference or fact in the record that would justify that conclusion. But I just want to make it sure it's clear that doesn't mean indefinite doesn't mean forever. You can make orders non-modifiable if you want to do it. There's a process for doing it. But in this case, the parties didn't do it. This was a default decree, not a consent decree. And so it was always modifiable on a substantial and continuing change of circumstances. The last thing I'll address in the few minutes that I have left is the attorney's fees. That's been raised by the appellant in this particular case. It's a small amount of money. It doesn't justify an extreme amount of time. But the court had made a finding, or I should say this, the court entered the order without a finding with regard to what was either unreasonable or reasonable. We know it wasn't based on the respective financial resources because the parties had a gross disparity of income in this particular case. But we do know that the position, and you will probably ask in your own minds, well, what was unreasonable about the attorney's fees order and the mother's position about attorney's fees in this case? And the thing that's unreasonable, the inference is, because she asked for the same relief twice. She'd already had a hearing, raised all of the same arguments, and then filed a motion for new trial and raised them again. That has to be the reason why Judge White had decided to, at least on that point, order the attorney's fees to be done. Any other questions from the court?
You or whoever was representing the husband and father argued, right?
Say that one more time, sorry.
You argued that it was unreasonable because she'd raised the issue twice.
Correct. It was raised at the time there was an application for attorney's fees and a China doll affidavit that was submitted.
That was the basis for the application.
That was the reason for the application. Any other questions from the court? Thank you very much.
Mr. Edwards.
I guess I didn't realize if you file a motion for new trial or a motion to amend and cite alleged legal error that's automatically a fee award, even though that's what the purpose of the motion is to say the court erred in the first time. One of the things I think that Judge Brown that you pointed out that's kind of one of the main themes throughout our brief here is, and that counsel just admitted, was that father believed mother could earn this $42,000 all the way backwards. Then there is no change. If that's his position, there is no change because that was his position at the time of the decree. Now, counsel repeatedly said this is a default decree. Leaves out the part how they both attended the hearing and negotiated the terms and testified about the default decree at the default hearing. It was all intents and purposes a consent decree done by default. They both admitted in their testimony they negotiated so forth. This wasn't something just dad didn't show up and she, lined the decree full of favorable terms to herself. They both testified in the hearing, not only the default hearing, but the trial in this case, that they negotiated the terms, thought they were appropriate, fully discussed it, and attended the hearing. But this issue of the $42,500 is the key here. If they both thought she could earn this at the time they negotiated, there's no change. If I think you can earn this money, there is no change. That's what the Marquez case says, and Linton and these other cases, they say if it's a reasonably predicted income, and then they meet that reasonable prediction, then there can't be a change. It's when it's a complete unknown that there's a change. Here, father stated he thought even prior to the 2014 that she could earn $42,500. If that was the case, he can't show the change. The issue on 527, and trying to distinguish between this issue of no upward deviation versus no downward deviation. The court's minute entry, we do have a very specific finding here. The court says the court finds that no deviation is appropriate. It doesn't say the court finds that mother's request for an upward deviation is inappropriate. It says no deviation is appropriate. So even if the court believes that 527 can apply or isn't the sole remedy here, the remedy given by the Allen court, and I'd agree with counsel that I haven't seen even a memo on this issue, but the remedy given by the Allen court is you'd have to find that the deviation is appropriate. Here we have a specific finding that it was not appropriate. My last 5 seconds. The percentages, the one thing on the percentages, it was twofold for the uncovered expenses. The court didn't order that retroactively backwards with the child support modification. So even if it was, that application has to go back the 3 years that this court was in place, because mother under the deviation was paying 100% of those expenses. So if the percentage, even at 50-50, that has to go backwards, because otherwise the prior order where she was paying 100% doesn't line up with now 50% only going forward after 3 years later. Thank you.
Thank you. Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We'll take a short break to prepare for the next argument.